What's your name, sir? What's your name, sir?
Anthony Clout.
We're ready on the Clout matter, Your Honor.
Okay. Is that with a K?
Number 29, Your Honor. Klauck.
25 CR 5887, People versus Clout.
Kevin Warden for the people.
Good morning, Your Honor. Robert Levine on behalf of Mr. Klauck, who appears to my right in custody.
Okay, good morning.
And thank you, Your Honor. We've been working on disposition in this matter. Mr. Klauck informs me today that he would like to set the matter for motions and jury trial. So we would ask the matter be set for motions and jury trial.
All right, you want to enter a not guilty plea? Do you correct? And
At this time, Your Honor, I would like to relieve Mr. Robert Levine as my counsel, and I would like to enter a plea of not guilty, Your Honor.
are you asking to go pro se, or what are you asking for?
I am firing Robert Levine for violation of Title 18 United States Code 241 under conspiracy against one's rights. I have also have some motions in my pocket in regards to complete dismissal of all charges, Your Honor.
Are you asking to proceed pro se? Are you asking the court to appoint alternate counsel? Let's start one at a time.
Alternate counsel, Your Honor.
Mr. Levine, are you ADC or are you private?
Your Honor, I am ADC and I work for Mr. Reich, who was appointed on the case as well.
Okay. So Mr. Reich is the appointed counsel.
Correct.
Right. Okay.
We open with the defendant appearing in custody, already convinced his own attorney is working against him. Before the court can even settle into the hearing, he announces his intention to fire his lawyer, accusing him of violating due process and engaging in conspiracies. The judge immediately slows things down, trying to understand whether the defendant wants to represent himself or simply swap lawyers. Right out of the gate, confusion sets the tone.
Okay, and you're with his office. Okay, Mr. Klauck, in order for the court to appoint counsel other than the one that's already appointed, I have to make a finding that there's a legal or ethical conflict. Are you asserting a legal or ethical conflict?
Yes, ma'am, Your Honor, for violation of my constitutional rights of due process, and not only that, but also committing a conspiracy against me under Title 18 United States Code 241, Your Honor.
Okay, here's what I'm going to do, because I have a pretty long big docket. I'm just going to pass your matter. We'll call your matter at the end of the docket, sir. You can provide whatever information you want, but I need to make that initial determination before I can proceed in either direction, and then you'll have some decisions to make. Okay? So we'll recall your case at the end of docket.
Yes, ma'am, Your Honor.
Okay.
Your Honor, I straight fired this dude multiple times. He is not my attorney.
This is our motion to adjourn.
Mr. Klauck, we're going to call your case and then we can have a conversation, okay? This is 8 on the docket, 25 CR 5887, People versus Anthony Klauck.
Kevin Warden for the people.
Rob Levine on behalf of Mr. Klauck, who appears to my right in custody.
Okay. Good morning, Mr. Klauck. First, I wanted to say I told you on Monday that we'd hear you that afternoon. I was unable to do so because counsel were not available, so that's why we had to reset you for today. Any questions on that?
No, ma'am.
Okay. On Monday, I had set the matter over because, as I understood from Mr. Klauck, he wanted alternate counsel appointed. I indicated that I need to hear some more information on that. And then since that time, there's a pending motion filed by counsel indicating that they are requesting to withdraw. Is that accurate?
Yes, Your Honor.
Okay. The motion indicates that the basis for the withdrawal is that Mr. Klauck wanted to proceed pro se, which is not what I understood on Monday. Is something changed?
The court explains the basics, you don't get a new lawyer just because you're unhappy. There must be a real legal or ethical conflict. The defendant insists there is one, repeatedly citing federal statutes and constitutional language, but without clearly explaining how his attorney created the problem. Sensing the conversation is going nowhere fast, the judge delays the matter to give it proper attention.
Changed.
Your Honor, that's based on my meeting with Mr. Klauk yesterday. That's the representation he made to me.
Okay. Mr. Clark, let me ask you, again, that's not what I understood you to be saying on Monday. Are you asking to proceed pro se, or are you asking the court appoint another attorney to represent you?
I would like the court to appoint another attorney based upon my Miranda rights, Your Honor, due to Mr. Robert Levine violating Title 18 United States Code 241, conspiracy against one's rights, and violation of due process under the Fifth Amendment of the United States Constitution and Article 2, Section 25 of the Colorado Constitution as well, Your Honor.
Okay. So a couple things there. I'm just going to advise you generally. You have court-appointed counsel. You are entitled to court-appointed counsel when you are determined to be indigent and you're in custody, so you're determined to be indigent. The court appoints counsel. In your circumstance, there was a conflict with the public defender's office that was determined earlier on. Based on that conflict, you were appointed, I believe, technically it was the law office of Scott Reich was appointed, but Mr. Levine has been representing you, is that correct?
Yes, ma'am, Your Honor.
Okay. In order for the court to find a similar conflict or another conflict that would warrant appointment of yet another counsel, I can only do that if I find that there is a legal or ethical conflict. Does that make sense?
I would think that there would be a legal conflict based upon violation of due process, Your Honor.
So what I want to say this is, in order to make that determination, I'm going to have to ask you for some more information on what you assert the legal conflict is. I want to advise you ahead of time that any conflict allegations that you make, to the extent that they may touch on privileged information between you and your...
Days later, the case returns, and things only escalate. Defense counsel files a motion to withdraw, explaining that the defendant now claims he wants to represent himself. The judge presses the defendant directly, asking him to clarify his position. He responds by doubling down, accusing his attorney of violating Miranda rights, due process, and multiple constitutional protections.
Counsel, that privilege would be waived as it relates to the conflicts that you assert. Same with confidentiality. It would be waived as to any conflicts you assert. Your attorney would be able, and indeed I would require that they respond to any allegations. Do you understand that you're waiving any privilege or confidentiality?
Yes, ma'am, Your Honor.
Okay. Help me understand, what is the, you mentioned the conflict has to do with Miranda. What is that?
In regards to Miranda, I actually have written motions that I would like to submit to the court and also the people as well, Your Honor. Is that possible?
I can't do it directly. You'd have to file it with the clerk so you can mail it.
Well, once again, Your Honor, I am in custody and I cannot file it with a clerk, and all I can do is written motions, Your Honor.
Yes, written motions are often filed by people in custody. You can do that through the jail in the mail. But if you'd like to make a record, and if that is in just reading from the motion, I'm happy to hear.
Yes, ma'am. I'd like to read the motion if that's possible, Your Honor. Motion to dismiss date 12/19/2025, defendant Anthony D. Klauk, who is present, Your Honor. Motion to dismiss charges in the Denver District Court Case 25095887. And the discovery, it can be seen.
Sorry, Mr. Clark, I'm going to stop you there. I'm not hearing a motion to dismiss charges. If you have motions relating to the conflict with your counsel...
And in regards to my counsel, Your Honor, I told him about the mistreatment I was going through in the county jail, and he still proceeded to want me to remain in custody. He still proceeded to try to cover up the fact that my rights were being violated in the county jail, Your Honor. And I gave him plenty of documentation and even have a grievance form that I even submitted to the county jail of the jail, violating the False Records Act, False Claims Act as well, with multiple officers violating their oath of office that they signed with the affidavit to the state of Colorado in regards to their oath of office to the United States Constitution, the Colorado Constitution, uphold and enforce the laws in the state of Colorado, Your Honor.
Here's where the cracks start showing. The judge calmly explains that Miranda issues, discovery disputes, or weaknesses in the prosecution's case are litigation matters, not conflicts. These are things lawyers argue in motions and at trial. They are not grounds to fire appointed counsel. The defendant, however, treats every grievance as proof of corruption.
Okay, is that a separate issue from Miranda?
In regards to Miranda, it's regards to all the officers involved. I was never read my Miranda rights, Your Honor. And this is also found in the discovery as well, which means every officer involved in my arrest violated due process under the Fifth Amendment of the United States Constitution and Article 2, Section 25 of the Colorado Constitution. And also, with that being said, Your Honor, Title 18, United States Code 1918, is being violated by the oath of officers who are testifying against me or going to testify against me in the upcoming trial, Your Honor. And based upon my knowledge under Title 18, United States Code 1918, even the prosecutors themselves can confirm that that is a felony. And not only that, but also violating Title 18, United States Code 241, conspiracy against my rights, and Title 18, United States Code 242, deprivation of rights under the color of law, which is also felonies, Your Honor. And with Mr. Robert Levine violating due process and also committing felonies of conspiracy against my rights after he was informed, Your Honor, once again, confidentiality has been waived, as we agreed. And I did speak to my attorney about my rights being violated in the Denver Detention Center, downtown Denver Detention Center. And this seems to have not been reported to anybody. And I've been trying to report this to the Federal Bureau of Investigations and also to the Department of Justice Civil Rights Division.
The focus shifts to conditions inside the jail. The defendant claims mistreatment, falsified records, and religious discrimination. He insists his attorney failed to report these issues to prosecutors or federal authorities. The court listens, but makes it clear, criminal defense lawyers are not appointed to litigate civil rights claims against jails. That's a separate legal lane entirely.
In the jail, and what are you asserting Mr. Klauck is doing or not doing that creates the conflict with respect to that? Or I'm sorry, that Mr. Levine is doing or not doing?
Not informing the district attorney, prosecutor of the matters in regards to crimes being committed against me and me being discriminated in the Denver downtown detention center of my First Amendment under protection under religion, the Colorado Constitution, Article 2, Section 4, freedom of my religion, also violating the Civil Rights Act of 1967, Your Honor, discriminated against me under religion. Also, the state law of the Colorado Anti-Discrimination Act of 2013, also discrimination under religion, and not to mention violation of the federal law of the Religious Freedom Restoration Act of 1993. And I would like the court to know that as a Messianic Jew, I am kosher and do both Old and New Testament and the Holy Bible. And with that being said, I am also protected under the Anti-Semitism Act of 2023, Your Honor.
Is there anything further?
Other than that, my attorney clearly seen in the discovery that violation of due process, in addition to him being aware of my rights being violated in jail, also in the discovery that was submitted, the perjury was done, and the persecution of the state of Colorado still wants to proceed in this matter, which means they would be violating due process as well, which means they would be violating their oath of office to the United States Constitution, based upon Matthew, who is one of the names in the mandatory protection order in my case in the discovery, committed perjury with two different names of Cecilia and Sabrina, submitting false evidence through Sarah Michaels at University Health, committing perjury and also violating the federal law of the False Claims Act. And the matter that he still wants to pursue the case and not defend me and bring this to the prosecution's attention. As
the defendant continues, the list of accusations grows longer and more tangled. Federal statutes are cited rapid fire, officers are accused of perjury, and prosecutors are painted as conspirators. The courtroom dynamic changes. The judge now has to separate emotional frustration from legal relevance, keeping the hearing anchored in reality.
This is a conflict of interest based upon due process that not only is Robert Levine also violating due process, but also the state of Colorado under the prosecution as well, Your Honor.
Mr. Levine, did you want to respond to anything?
Briefly, I think what he is actually referring to is the SBI forms in the case. That's something we discussed. The SBI forms contain different names than the alleged victims in the case, possibly an oversight from Denver Health. I've explained to Mr. Klauck that having the wrong names on the SBI form doesn't necessarily mean that they can't prove the second degree assault allegations. That would probably be something that would be fixed pre-trial with endorsement of the medical professional. I've met with Mr. Klauck 4 times during the pendency of the case. I'm realize that he has interest in getting out of custody and expediting this matter, and I've tried to take that seriously and step my foot on the gas for Mr. Klauck here in negotiating the case and kind of trying to move things along. There is a misdemeanor offer here. It's a misdemeanor probation offer.
I think we don't need to get into that. Seems a little outside.
Okay.
Anything further on what he's asserting on the conflict?
Your Honor, there have been issues with the jail. I know I spoke to Mr. Klauck's mother, who called before court on Monday. I tried to see Mr. Klauck before Monday. I went to the jail, but by the time I went to the
Defense counsel finally responds, clarifying the confusion around discovery documents and alleged name discrepancies. He explains that administrative errors don't erase criminal charges and can often be corrected before trial. He also confirms multiple meetings with the defendant and ongoing efforts to move the case forward, including negotiations for a reduced outcome.
Jail, they had transported him here. There's been transportation issues with Mr. Klauck, so it's been hard to see him before court on several occasions. But I met with him 4 or 5 times to discuss his concerns and to discuss the case.
All right, Mr. Klauck, as I indicated, in order to appoint yet another counsel, I have to make a conflict finding. I've heard what you've said. Let me just try and address as best I can the asserted conflict issues. 18 U.S.C. 1918 is a federal statute involving disloyalty and asserting the right to strike against the government. It's really not applicable here in any way and would not qualify as a legal or ethical conflict. As to issues regarding whether or not Miranda rights were violated, whether or not there are discrepancies in the discovery, and whether the case is provable, those are not conflict issues. Those are issues that are subject potentially to litigation. I haven't read your discovery. I don't know whether there is a Miranda violation or not. If there are weaknesses in the people's case because of documents, those are trial and motions hearings issues, but those don't rise to the level of a conflict. That's what litigation is for and what it's about. As to your assertion that there's a conflict because Mr. Levine has not done enough from your perspective to address what is potentially some civil rights or First Amendment issues that you're experiencing at the jail, Mr. Levine is appointed to represent you on the criminal matter. Pursuing civil rights lawsuits, he would not be appointed on those. Those are not within the purview of his appointment. It sounds like he's made some steps.
The judge delivers the turning point. One by one, she dismantles the conflict claims. Federal statutes cited don't apply. Miranda issues are trial matters. Jail conditions fall outside appointed counsel's role. Frustration with strategy is not a conflict. The ruling is firm. The request for a new lawyer is denied.
To try and address them, but and that's great, but that's not within the purview of his appointment. And so to the extent that he's not doing what you want him to do on that again would not rise to the level of any sort of conflict, legal or ethical, that would warrant appointment of alternate defense counsel. So your request for alternate counsel to be appointed is denied. With that, you have some options. One is you can proceed with appointed counsel as appointed, or you can request to proceed pro se. As I indicated previously, if you want to proceed pro se, I need to do what's called an arguello advisement. I would not allow counsel to withdraw. You can't just fire counsel when you have court-appointed counsel unless I can make a finding that you have the ability and that you are knowingly, voluntarily, and intelligently waiving your right to court-appointed counsel. What would you like to do between those two choices?
I'll stick to the word of God and go pro se, Your Honor.
Called an arguello advisement with you. Arguello is just a case that talks about what types of advisements and findings I would need to make for you to proceed pro se.
I have a copy for Mr. Clark if there were no changes.
I haven't looked at it, so why don't you, I'm going to have you follow along, sir, because you're going to have to initial these in understanding. Mr. Wharton's going to give you an advisement of your right to counsel. Okay, you have that written advisement in front of you?
Yes, Your Honor.
All right. It's entitled Advisement of Right to Counsel. To the defendant, Anthony.
Now comes the choice. The defendant can continue with appointed counsel, or represent himself. The judge explains that self-representation isn't symbolic or spiritual, it's a legal decision with serious consequences. The court will not allow a lawyer to be fired unless the defendant knowingly and intelligently waives that right.
Anthony D. Clark, that's you. Before accepting your decision to waive representation by counsel and letting you proceed pro se, the court advises you that the effect and consequences of your decisions are as follows. 1, a criminally accused enjoys the constitutional right to self-representation through the United States and Colorado constitutions. The right to self-representation is personal to you and may not be abridged by compelling you to accept a lawyer when you desire to represent yourself, citing People versus Romero. Do you acknowledge that understanding?
Yes, ma'am, Your Honor.
Okay, do you have a pen?
I do not, Your
I'm
Honor.
going to ask you to put your initials there. Sir, do you understand that you have the right to be represented by counsel throughout these proceedings?
Yes, ma'am, Your Honor.
Please put your initials. Do you understand that if you cannot afford an attorney, one will be provided to you free of charge? And indeed, that's court-appointed counsel Scott Reich's firm and Mr. Levine in this circumstance.
Yes, ma'am, Your Honor.
Okay, initials there, please. Do you understand I will appoint counsel, or rather continue appointed counsel if you want an attorney to represent you?
Yes, ma'am, Your Honor.
Okay, initials there for me. Regarding the relevant charges, do you understand as follows that the charges are against you are count 1, assault in the second degree, a class 4 felony.
Yes, ma'am, Your Honor.
That's an F4 felony. It carries a presumptive Department of Correction sentence between 5 and 16 years. That's a non-mandatory Department of Correction sentence. Do you understand that?
Yes, ma'am, Your Honor.
Initials there, please. I don't think it can be as little as 1 year.
I actually wasn't sure at that time with the extraordinary because it is a different sentencing structure than your standard F4.
It's
So
a 5 to 16 non-mandatory. 5's the minimum.
Correct.
I
Okay.
can't find mitigation, right?
I guess not. No.
Okay. Mr. Klauk, I'm gonna cross out as little as 1 year. The sentence on this matter is 5 to 16 years. If you are probation eligible, probation may be an option. I'm gonna cross out the next paragraph. It's not applicable. It is followed by 3 years of mandatory parole. Do you understand that?
Yes, ma'am, Your Honor.
And there's possible fine between $2,000 and $500,000. The count 2 is assault in the third degree. That's a class 1 misdemeanor.
Against all warnings, the defendant chooses to go forward alone. The judge begins the formal advisement, carefully explaining the charges and the potential sentence, up to 16 years in prison. Every right, every risk, every consequence is laid out in plain language. And just like that, the case crosses a line, from misguided confidence into full legal jeopardy, with no one left to blame but the person holding the pen.